Good afternoon. Today is April 10, 2024. Welcome to the April 2024 monthly OJCC podcast, unCOMPlex. I am not David Langham. I am Thomas Hedler. I'm a JCC in West Palm Beach. I am filling in today, hopefully without more complications, especially considering the podcast is titled unCOMPlex. So we're going to try to move into some topics of discussion. I do have some people in the Zoom and the chat is open. So please feel free to add any issue or topic or question that you may have in the chat. In the interim, though, I thought it would be a good idea to discuss some of the things that are going up with respect to the OJCC. I do want to reiterate the announcement that the OJCC does have a YouTube page. It is the YouTube page at FLJCC. It is where Judge Langham is storing his unCOMPlex monthly podcast. It is also where we have now started dropping the WCI OJCC seminar rebroadcast from the March 1, 2024 seminar at the first EPA. We recorded each of those sessions and we are going to drop each of them on a weekly basis. We just started this past Monday, I believe, the JCC panel that was put on the YouTube page. So hopefully the YouTube page will garner some more traction and more information, and can be an opportunity for further engagement between and the practitioners in the bar. Another thing we've got going on, obviously, is forum conferences next Wednesday through Friday. Wednesday, we will be having a JCC and mediator reception. People. A pre-reception to the program. It's going to be in the Osceola foyer, and that'll be at 5:30. I believe the regular pre-forum reception starts at 6:30. So we'll be meeting a little earlier, and we invite anyone to come join us and meet with the JCCs, meet with mediators. Judge Langham will be there. I believe Judge Schwartz, our chief judge, will be there. And so we welcome you all to that. Also want to remind everyone about the OJCC Scholars Program that is getting ready to start. That is for lawyers that want to take a deep dive into workers' comp. Does require a letter of recommendation from a JCC or Judge Langham. So if you have any interest, send a note to your local JCC or to Judge Langham so you can potentially participate in that. It should be a good program. Other than that, we have a number of different programs and issues going on around the state. Locally here in West Palm Beach, we have the Palm Beach County Bar Work Comp Annual Seminar happening in May. I know the FWA conference is in June. I know of those two events because I happen to be speaking at those two events, so I certainly welcome your attendance there as well. I'd love to meet with anyone that is watching this podcast. So without further ado, let's jump into some topics. We recently had a meet and greet or a round table that the work comp section put together in West Palm Beach. And we met with a bunch of lawyers and we had a great time. Some of the questions that were asked prompted some great discussion. And I wanted to kind of start with one of the first questions we received during that Q&A session. And that is going back to essentially something that we all seem to be struggling with, even though it's been 8 years since the Miles case came out. And that is what lawyers need to do to get their Miles fees approved, potentially approved with less scrutiny than they are accustomed, and approved maybe without a hearing. So I wanted to go through some basic topics with respect to Miles settlement fees. I know this is a topic that is discussed quite frequently, and it seems even when we don't want to discuss it, it is the first question that we face. And so I figured we'd jump right into that. right out of the gate. So let's go over your miles fee settlements. I do understand and appreciate that different judges across the state are viewing miles somewhat differently. I've heard of different nuances and requirements. I've heard of other things that were not required. So I know it's difficult. I've heard of some lawyers, some firms, maybe a lot of them have differing lists for what each judge requires. And I understand the frustration, the difficulty with that. I don't see that changing anytime soon unless First DCA speaks on miles and offers us some further clarification. But let's talk about some basics. First basic issue would be really, do you have the requisite documentation for your miles fee? I would imagine a large majority of judges across the state would require that you're going to have your motion, make sure it's signed by the injured worker. You have to have the attorney fee data sheet. That's definite. That's in the rules. And most require an affidavit in support of an excess fee, since I think most judges view it as an excess fee. And then most, I believe, require a copy of the retainer agreement and the waiver. That would make the miles agreement legally sufficient. And so those, sometimes we get these packages for miles settlements, and they don't have all the documentation even. So notice of deficiency, or some judges will deny without prejudice. So at the very least, I would make sure you have someone in your office, if not yourself, going through the packet of documents that are being uploaded and making sure that all the documents are there. That's first and foremost. Then let's talk about, are the documents completed properly? It seems like there's been a rash of attorney fee data sheets that are incomplete, not filled out. Those oftentimes pertain to side fee agreements, but even miles fee agreements, we don't see many times the attorney fee data sheet completed as it should. You guys should understand that the attorney fee data sheet is the mechanism that we utilize in documenting all of the data for settlements, which is legislatively required in the statute. And Judge Langham has to put forth the annual report detailing the information that we gather. And so the attorney fee data sheet is what we rely upon when we upload our orders and document and gather the data with respect to the settlement. So getting the attorney fee data sheet completed properly is crucial. And again, we do see a lot of deficiencies here, certainly more recently with respect to stipulations as well. And we can potentially get into that if we get into stipulations for employer carrier paid fees. I know Judge Sancerni's in the Zoom, and she would love nothing more than to have an entire podcast devoted to this. I'm not going to do that here today. Don't unmute yourself. We're not ready for you yet. What? We're not going to focus on attorney fee data sheets in the detail that you would wish. But if we've got some time, we have no questions, and we run out of material, then by all means, Judge Sancerni can join me, and we can go through a little further tutorial on attorney fee data sheets. Does a retainer provide for the requested fee? That's been another issue that's popped up recently. There are a number of retainer agreements that have tiers or staggering different percentages under different scenarios. Some of those retainer agreements are not incredibly clear, or they are clear in the wrong way that you want them to be clear. And that is, you'll have a lighter percentage for the time that if you file a petition or if there's a denial, and then there's another increased percentage for similar, the same language as the initial percentage, and then added with the caveat of and through the final hearing. That's been problematic. So making sure that your retainer agreement clearly delineates what you are seeking with respect to your fee, and that your client agreed to that, is another important factor, and it's an issue that we've seen more recently. Was the waiver completed at the time of the retainer? That's another issue that we've seen. We've seen some waivers that were executed after the fact, and that becomes potentially problematic. That may result in a hearing and some further inquiry with respect to that. Does the waiver need to be notarized? There are some judges that I believe adhere to that interpretation. We may have some in the Zoom here today, and again, maybe we can call that out and maybe get some further explanation on that. Because I'm certainly open to being joined here with respect to this podcast here today. I don't think anyone who wants to listen to me blather on for 45 to 60 minutes. And then getting into the affidavit. The affidavit to me is probably the biggest violator of Miles fee motions that incur heavier scrutiny than what you may want. And that is because the affidavit very frequently is form generic language that is not informative in any way, shape, or form. There seems to be among a cadre of lawyers that have shown themselves to be incredibly brilliant in workers' compensation, there seems to be oftentimes a lack of creativity, a lack of ingenuity, a lack of focus with respect to the factors. The factors, as you well know, were codified into the rules regulating the Florida bar and codified from the Lee Engineering case. There are factors A through H. It's not uncommon that we get affidavits that don't identify those factors in that order or even in totality. And it seems that a very common error or area of concern or inviting scrutiny is predicated upon the fact that many lawyers focus almost entirely on subfactor A. And even within that, they will focus almost entirely on the time and labor required. And that is, they will give you the time that results in an hourly fee that they think is reasonable, and they think that should be the be all end all. I don't think that the Florida bar meant for sub A to be the be all end all. In fact, I'm quite certain that is not the intent at all. I believe the Rudolph opinion addresses this as well. It was certainly an argument that was raised by the claimant's attorney and the correct argument to be raised, and that is whether or not all the factors are fully considered. It is hard to consider all the factors if they are not fully addressed. And so I would certainly encourage claimants attorneys that may be wanting this in the future to spend some time reacquainting yourself with the factors and taking a look at your form affidavits with respect to Miles. We have a tremendous amount of legal memoranda within the affidavits advising why the factors are not applicable any longer. But then we have very limited information within the actual factors themselves. And that makes it difficult for a judge to assess the reasonableness of the fee. And then there are oftentimes a hearing is set. And then at that hearing, I know personally for me, much of the discussion focuses on the fact that the factors are not complete. They're not informative. They offer no detail. And the usual course after that is for the lawyer to do an amended affidavit. This could be avoided, and many hearings could be deemed unnecessary and not take place, and you can have your orders entered a lot quicker than what you may be facing if you're getting hearings set on the motions for Miles fees. So we definitely encourage the claimants bar to spend some time really looking at the factors and spending some time focusing on the fact that the factors are there to allow you to utilize those areas to assess that the fee is reasonable. One of the factors that I very frequently see completely underutilized is the amount involved or the amount obtained on behalf of the injured worker. And what I see very frequently is that the lawyer will simply identify the value of the settlement as the only thing that was obtained. You'll see this in many respects when the lawyer has been representing the injured worker for months, if not years, and has filed multiple petitions, presumably many of which were followed by the provision of benefits. And so why some, the claimant side, are not identifying those benefits, not identifying all the different work that was done through the life of the claim is something that leaves me at a loss. And it's something that, again, can present our documentation in such a way that we can get these settlement orders out very quickly. Most of the time, if we're here in the office and we're not in hearing, and we've got our motions being submitted to us in our folder system, most of us can get these orders out potentially same day, if not certainly within 24 hours. And it is the motions that are oftentimes deficient, sometimes legally deficient that warrant a denial or a notice of deficiency, sometimes just substantively deficient that causes further inquiry. And so if we can avoid that by focusing on what is required, I think by most judges, we can probably make some greater progress towards getting settlement orders executed and completed in a more timely fashion and without the heavier scrutiny that some of you all may be seeing. Perhaps not, but certainly something worth trying. We did these town hall meetings in a manner that we moved to different rooms. And it was interesting to see different rooms have a series of different questions. And so again, unless or until I start seeing some questions in the chat box, which is open and you guys are more than happy to throw something in there and I'll address it if I can. I'll go into the next area that was brought up, and unsurprisingly, it was the issue with respect to stipulations for employer carrier paid fees. I am aware that there is an order, some orders, multiple orders across the state that have some lawyers and a bit of a holding pattern with respect to how they typically handled settlement negotiations. And that is, it was quite frequent that a settlement would be reached and the settlement would include the settlement of the benefits, but also a side stipulation. And many times that side stipulation is where for the very first time the import carrier is agreeing to provide a benefit that's presently being litigated to account for the exposure for the fees, which is perfectly permissible and acceptable. When you all are settling cases, we are all well aware, all the judges practice workers' compensation. We know how this works, that you are settling exposure. And if you are in the midst of litigation and there is exposure for attorney's fees, and you want to settle and reach compromise on that, there's nothing wrong with that. And there's certainly nothing wrong with even agreements where the import carrier still is not convinced that they owe you a fee. But they're willing to compromise on the issue because they understand there's exposure. Why is there exposure? There's exposure because there is presumably a justiciable issue with respect to the fee entitlement. If there is no justiciable issue with respect to the fee entitlement, i.e. there's no legal basis for the fee, then you very well may be placed in a situation where you're looking at an order that is similar to some of the orders that some of the lawyers are not happy with, and I understand that. What I've been told is that some of these orders have had kind of a freezing effect on employer carriers' willingness to enter into those compromises. Perfectly legal, perfectly acceptable, perfectly proper compromises historically, and now there's a lot of hesitation. I don't know how true that is. I presume it's true. It's been raised on a number of occasions and was a topic of discussion at our more recent event. So I did want to address that briefly here, because again, certainly don't want to have the one opportunity I have to stand in for the podcast and focus entirely on attorney's fees. But to the extent that there may be some misinterpretations or misapprehensions with respect to these orders, I do want to try to offer some clarification. And that is, again, there is absolutely nothing wrong with compromising on the exposure for attorney's fees. What we are looking at are issues that you start to see varying levels of conflicts arising. If you are in mediation or you're in negotiations and you all have reached a global settlement from which the lawyer is going to carve out an employer carrier paid fee or a stipulation for some benefits and an employer carrier paid fee, that is a precarious position for the lawyer to be in. I know there are some lawyers that will not allow themselves to be put in that position. I don't think it's to that extreme. I think you can mitigate the appearance or potential for conflict. But if the negotiations are taking place and it's all one basket, and then at the very end, there is a carve out, that is ripe for potential for conflict between the attorney and the injured worker, because what the attorney is carving out what they think is reasonable for their fee, they're taking away from the injured worker. So it's a pretty patent conflict in terms of it's kind of hard to deny that. So I would certainly encourage that if you are in negotiations and you are focused on that realm, that you do have some measures in place to protect or mitigate against the conflict. Some of those measures, again, to the more extreme are, I'm not going to negotiate my fee at the same time I'm negotiating the washout. I don't think that's absolutely necessary, but it's a good practice, certainly a safe practice to move forward. But there are other ways to handle that, one of which could be negotiating side by side throughout the process. So there's no misunderstanding. When you have a demand for the washout and you have a demand for the fee, and every negotiation is in sidestep with that. That would certainly help, especially when you're in mediation and your client can see, for the claimant side, they can see those negotiations taking place and they can understand in total that there are side agreements being focused upon. That may not necessarily be an absolute necessity either, although again, it's definitely leaning towards, I would submit, the better practice. At the very least, I would contend that you should have a conversation with your client beforehand, that maybe to the extent of we are going to be negotiating all in a lump sum, because I think that's going to help us both benefit and improve the quality of the offer that's made within the scope of the negotiation. So maybe strategically, you want to negotiate everything all in one. And again, that is permissible, but what are you doing to mitigate that potential for the conflict? I would certainly recommend something along the lines of conversation with your client where you explain your evaluation of the case with a range of values and your explanation with respect to your legal theory and your evaluation of the fee with a range of values, so that when you get to that bottom line, that there's some level of correlation from the starting point to the ending point, and the injured worker understands that that process has taken place and there's no surprise. It is an unfortunate and difficult experience when you are a judge at an evidentiary hearing, a motion to enforce, and what you're hearing from the injured worker is, I had no idea that they were really paying a total of $20,000. I thought they were only paying the $10,000 that my case settled for. That's problematic. And so I would certainly imagine that any claims attorney that is focused on being an ethical and professional lawyer and advocating for their client's interests can acknowledge and address that. So the starting point of is there a carve out is really kind of that opening analysis of whether or not there's scrutiny on this side arrangement. But even that oftentimes happens all the time. It's understandable. It's part of our practice. However, when you get to that scenario, then you've got a set of eyes looking at it maybe a little bit more carefully. And at that point, we are looking at the stipulation. Is this a situation where the employer carrier is stipulating to the entitlement, stipulating to the amount? Does the stipulation provide detail and explanation as to what is being ascertained and agreed upon and why? If not, if it's a situation where the employer carrier position is we don't think we owe you the fee and we're fighting this. We understand there's exposure for it, so we're willing to compromise on that level. That's okay too. You can have a stipulation where the employer carrier goes that far and no further. But when you have that scenario, I oftentimes will focus on the affidavit at that point. Because I want that affidavit and the attorney fee data sheet to outline the basis for your claim for fees and the basis for the legitimacy of the fee. You don't have to go through and have a stellar or even winning argument on the matter, but you should be able to outline a justiciable controversy. And that to me is a baseline controversy that there is some legal merit. There is some finding of fact and law that supports your argument. Again, it may not be a great argument, but there should be that base. If there is no base for that, if there's just absolutely no legal sufficiency or support for your stipulation, then you need to be very careful about moving forward, because as you both file a stipulation, you are making a representation to the judge that this is a well-grounded pleading in the law and in fact. And if it isn't, then you potentially, if not outright, have violated 440.32, and it creates a problem because sanctions are mandatory under that provision. So again, to hopefully offer some clarification, this is not a scenario, at least for me and many of the judges I've spoken to, it's not a scenario where the fee has to be absolute, that the fee has to be really solid. This is a situation where there's got to be a legal basis for the fee. And if there's no legal basis for the fee facially, there's nothing there for the fee, then that's where you start to see some of the problems that the orders that have created a bit of a stir are predicated upon. And so that's something that to the extent we can have more dialogue and try to avoid that, I think that suits everyone. There's also a situation where you start looking at the amounts, and that's where we start getting into the weeds, but we'll use an extreme example and try to move on so we're not focused entirely on these with respect to this podcast. But the amounts. So again, you have a scenario where you've agreed to settle the case. You've been representing the injured worker for 4 years. You filed 15 different petitions, and the stipulation, your attorney fee data sheet, and your affidavit all identify one petition for which you had fee entitlement. Your stipulation and or your affidavit identify the petition date and when the benefit was provided. Maybe it's within 60 days. Still, you're entitled to a fee. You should get a fee. But then the fee that they're paying is for all time expended over the 4 years of the claim. That's facially a problem because there's no legal support to make the argument that you get paid for 4 years, 15 petitions, when everyone is on the same page that you're only entitled to employer carrier paid fees for one petition. So again, that's a bit of an extreme. Unfortunately, it's an extreme that I've seen. So it's not unheard of. This is not some theoretical in a lab. Again, this is a scenario where that's just facially problematic. And when the employer carrier is agreeing to that, they can't put their head in the sand and say, we didn't know anything. There's some logic here. There's some rational bases for an argument, again, predicated upon exposure. That's what you're settling for. So I would encourage the lawyers to not be scared away from entering into agreements that are perfectly legal and viable and capture the proper exposures when they're talking about settling claims. But at the same time, I would certainly continue to advise or encourage lawyers to be careful when you're entering into these agreements. And I understand the issues that are going on with respect to my client just wants to settle the case and I have a duty to my client, et cetera. You also, both lawyers have a duty to, under the Florida bar, to file the pleadings that are properly founded in fact and law. And your failure to do so can create problems, and your client should understand that. So I don't know if I've helped with that or created ongoing problems. Certainly the latter was not my intent, but I did want to address that because I had been hearing that's part of the chatter going on, and I understand it. And it's not something, again, that we're looking to create problems or have an agenda to let's figure out some ways to limit the fees. Most certainly not. It is a situation where we want the documentation to facially support the fee that we're approving. And you should want that as well to avoid any potential problems in the future that the lawyers may have with the bar, that the lawyers may have with their client. It's just a scenario where it's required with respect to the review of the fees. And I know there's a movement or a desire to get away from that even, but as long as we're there, I believe most judges are going to say they're going to try to do their job to the best of their ability, and that is to review the fees and make sure that they are facially supported. So that's kind of the extent that I wanted to address fees. There are some people in the Zoom, and I know primarily this is for after the fact viewing. Misgivings. Is there any other question or issue with respect to the fees that you guys would like me to address? Because I'm very happy to do so. If not, we do have other issues that we've been seeing across the state that I would like to address. The first of which, and again, jump in with the chat, I'm happy to address it. The non-fee issue that I would like to address pertains to appearance at hearings and mediations, and appearance at hearings and mediations in the manner that you are appearing. And that is to say, for hearings, I believe most judges are either doing Zoom or live. There are some judges that will still do open voice. I understand that. Actually, I don't understand that, but God bless. Zoom and live has become pretty much, I believe, the primary manner in which we conduct our hearings. And I know with mediation, the state mediations are defaulted to Zoom, at least for the opening. I understand. I don't know how that's all taken place. And I would, although as part of that design, I would certainly recommend at least the ending point as well. When you have the agreement, you can share a screen. That's one of the benefits of doing Zoom mediation. I think it helps the parties and certainly helps an injured worker who is not necessarily sophisticated in understanding of the complexities of the law in general, and certainly not workers' compensation. So Zoom is kind of the base for how we're doing our mediations. And again, it is a very frequent mechanism in which we conduct our hearings. I do understand that a lot of private mediations are still taking place telephonically. So I'm not going to address that. But as it pertains to Zoom appearance, there seems to be some with the, I would contend a misconception as to what is required with respect to a Zoom appearance. And that is the belief that if it's not live, then Zoom allows for a completely different level of presentation with respect to your hearing or your mediation. That is not dressed properly, not adequately prepared, don't want to put the camera on, don't want to have video appearance or not a professional video appearance. That is, at least from my perspective, and I know some others, if not most others, at least with the JCC, I would certainly contend, since I'm on the podcast here today, I would say that's absolutely false. The Zoom appearance, in my mind, is an accommodation, and it's a desire to take advantage of the efficiencies that we were able to gain from the COVID pandemic. And so the point of Zoom is to allow everyone to operate with a level of efficiency. It is an accommodation. It is an alternate way that you are presenting or making a representation at a mediation or a hearing. And that is alternate from live. In other words, you should, my estimate, be attending your hearings and your mediation in Zoom in the same manner as though you were appearing live. That is, Zoom denotes video conference, video meaning visual. So we're looking for the opportunity to see you. And when we see you, you should be professionally attired. Oh, now the judges are popping on with their video. I appreciate that. You should be professionally attired, and you should be also capable and able to represent your client's interests at the same degree or a similar degree as though you were live. That is to say, I have lost count of how many Zoom hearings I have had that were conducted with a phone, which can be fine. But when you are going to do a Zoom hearing by phone, might I suggest you situate your phone in a stable place and have a focused visual. Walking around a room, walking around outside, being in your car, driving, those are not appropriate presentations or appearances at a hearing. There's no way that you can be focused on ascertaining the docket or your file materials and being able to respond to any inquiry that comes your way in a capable fashion for your client when you are not focused, prepared, and have access to all the information you need for that hearing. We are setting a hearing. You are to be appearing at a hearing where you are going to be making your argument on behalf of your client. You should have access to your file materials. You should have access to the docket. If you don't, then your appearance is, I would submit, substandard, and certainly substandard to live. So the notion that you can just do Zoom and it's so convenient, you can do it on the way to the supermarket, or you can do some laundry while you're doing this and knock two birds with one stone. That is not advisable in any way at all. And it's not something that I would accept as a proper appearance. And I would be inclined to no-show that kind of appearance. I personally do not see a lot of that. And so I feel incredibly blessed with the bar that practices here in West Palm Beach. I've been hearing rumors more along the lines of mediations, where lawyers don't want to turn on their camera. Maybe lawyers are not dressed appropriately and they are not focused on their case in the way that they should be. There have been some examples that Judges Sansoni and Case are filling the chat box with now. There have certainly been some examples with respect to hearing attendance as well that was less fortunate. We went through a series. I was a judge before, during, and after COVID now, so I saw the kind of the transition. There was definitely a learning curve. It's been 4 years now. The learning curve should be established. If you are hearing via Zoom, your focus should be on making that appearance as though you were live. And I certainly am aware of judges that take the position of, if you are frequent flyer of improper appearance, then you will get the dreaded mandatory live appearance at all events in the future. So the idea of taking advantage of Zoom is something that I think we should stay focused in a positive manner and take advantage of the fact that it is a great tool for efficiency, but it should not be abused. And to the extent that it has been, and maybe is continuing to be abused, maybe certainly on the mediation front, I would certainly recommend against. So that would be a topic that needs to be addressed. We've got some limited time. I'm not seeing questions in the chat, so I'm going to keep forging ahead here. Compliance with discovery, compliance with the rules, the statutes, orders. It seems to be an ongoing problem, maybe even a more heightened issue recently, it seems. I feel like I'm issuing a lot of orders to show cause. And it used to be, you had a lot of orders to show cause, typically against an injured worker who failed to appear at mediation. Those happen, I understand that. Those aren't the orders to show cause I've been entering more of lately. More and more, I'm entering orders to show cause for failure to comply with the order, for failure to upload a private mediation report, for failure to complete the pretrial stipulation. These are orders to show cause that I'd like to think we really should never see. And yet I feel like I'm issuing a good deal of those, and that's concerning. What's more concerning is a number of these orders to show causes are going without a response being filed. And so there is some heightened pattern of failure to comply with the discovery that got you to the order, compelling compliance with the discovery, failing to comply with that order, failing to respond to the order to show cause, and then maybe last minute, oh, dismiss the petitions, or oh, I responded now, and so let's make it all go away. That's not going to make it go away. If there's an order to show cause for failure to comply with an order, it is predicated upon a failure to comply with an order. When you do the response or provide the documentation well after the fact, and maybe the day before the show cause hearing, that is not complying with an order if the order tells you you have to produce the documents within 10 days or 20 days or 15 days, whatever it may be. So that's not compliance. A delayed response is not a timely or appropriate response. And so I would encourage you that if you get an order to show cause, you should respond, and you should respond with the focus of providing good cause, because failure to do so will likely lead to sanctions. It's just, and it's unfortunate because it seems unnecessary. And I'm seeing it with lawyers that I've known for a good deal and of time, and they're good, conscientious, professional lawyers. But the practice feels like it's been going in a bit of tornado style fashion, especially with the remote work. It seems more and more that it is clear that the lawyers are being run in kind of a human battery in the matrix, or the grossly overweight people in Wall-E type scenario where they're just event after event after event after event, and there's no room to breathe, there's no room to gather your thought, there's no driving time, there's no calm time, and it feels like that is driving a number of different practices, and it is creating a great deal of sloppiness and work product that just isn't sufficient or something that these lawyers would even feel comfortable with. There have been a number of hearings where the lawyers are embarrassed by their own work product, and it's not the point of the hearing by any stretch. And yet, it seems to be what's happening more frequently, and I'm becoming more and more convinced that, at least to some degree, the way that your calendars are being set, the way that you're being run on your files, is really not helping you. It's not healthy, and it's not conducive to a quality work product that you all, I'm sure, want to provide. So I don't know the answer to those questions philosophically, but to the extent that you are seeing more and more orders to show cause, more and more violations, more and more failures to comply with discovery rules, statute, et cetera, maybe should be kind of an opening eye experience with respect to some corrective measures that need to take place. Because I assure you, there's no contest among the JCCs of who's issuing the most orders to show cause, and there's no prize at the end. It is something that we really have no interest in doing, and we prefer not to. But if we're compelled to, we will, because we have to do our jobs. So, to the extent that further dialogue between the bar and the JCCs can or will help in that regard, we're happy to do so. I know our deputy chief, Judge Langham, is feverishly working toward creating more and more different environments, different opportunities for lawyers to engage with the judges and vice versa, so that we continue dialogue, so we continue to develop those working relationships where we don't have failure in professionalism, failure in ethical duties, or a substandard work product in our practice. And so certainly continue, as you are now, if you're watching this podcast, to take advantage of those opportunities, because we want that, and we know we can learn from you. We want to learn from you on how we can do better. And so we would encourage you to be engaged and to bring your voice and help us to get better. It is 12:50. I think he usually runs these between 45 to 60 minutes. So I've got some other topics. I'll throw out a question without necessarily going through providing an answer. With the EMA amendment, where the provision of an EMA is within the discretion of the JCC and not mandatory, and I understand we can spend some time on whether that's a procedural or substantive change. I'll refrain from that. Does beg the question of whether or not the Benuti case and the provisions under Benuti, i.e. you just put notice out to the judge and that's sufficient, and that gets an EMA, and that gets an EMA paid for by the import carrier. There's some question with respect to whether or not that's applicable. I'm curious about that. I'm curious about that argument being presented and asserted and addressed in a hearing, or even in an environment such as this, if anyone feels comfortable shouting out on that front or throwing out in the chat. Is there any other issues, topics that the bar would like to hear that we can address here today? That sense, Ernie, you unmuted. Go for it.
Well, I indicated in the chat room, I see this a lot, and since this is being recorded and hopefully some people will watch it, I thought it'd be good information. We get a lot sometimes, and maybe because it is Central Florida, and we think maybe even South Florida sees some of this too, but we'll get a lot of people who move around, and when we get the child support affidavit, with the approval of attorney's fees, the motion, we'll get, the person lived in Osceola County, but now lives in the state of Texas at the time of signing the settlement. And obviously, according to the 60Q rules, we are supposed to look at the child support arrearage, and we tend to not get any information about where the new state, where they're at. And I don't think most of our bar knows that if they go to our JCC website.
Do you want to share screen that real quick?
Absolutely.
You know you're on camera now.
I know.
Welcome to unCOMPlex, the monthly
There we go.
podcast.
Wait, wrong one. Here we go. So
Okay.
if you look at the home for JCC, if you go to resources, you'll see here where it says child support. If you go to the U.S. Department of Support Resources, it will take you to the next website. And that website actually has the contact information for every state and territory, including even Puerto Rico. And so you can go, for example, if I went here and the person lived in Kentucky, you go Kentucky, there's the contact information for the child support. So you can contact their office and be able to fax them something that maybe they can fax back or email back. And what I've generally has seen is I get sometimes I get even an affidavit from the paralegal of the claimant's attorney's office that says, I have contacted that person at the Department of Income Support for the state of Kentucky. I spoke to so-and-so, and they indicated that there was no account for this person for the claimant's name with, identifying their social security and date of birth, because maybe the state won't provide them anything because there's nothing to be provided. Or sometimes I get an email that says no account or something of that sort. But I think a lot of times our own bar doesn't even know that information is actually on our website that can assist. Because if not, you're going to get a notice of deficiency from my office, which we tend to, at least in our notice of deficiency, provide you with that link. But I thought maybe that would be some helpful information for anyone who watches this in the future.
Wonderful. Thank you for joining. And with that, if there are no further questions or issues, we will adjourn the April 2024 edition of unCOMPlex, the monthly OJCC podcast. Thank you for joining us, and thank you for watching. If you ultimately do, it's good to see you all. You all have a wonderful day.